My Lords, after all that excitement, I fear I might be a bit of an anticlimax, but I'm going to carry on regardless and let people walk out. My Lords, I rise to move my amendment 160A, which is calling for a review of the impact of the Act on the prison estate and the ongoing treatment and care of mentally disordered people in a prison setting a year after the Act passes. We've all welcomed the Bill's commitment to ending the use of prison cells as so-called places of safety. But as some of us have already noted in an earlier group, the promise of, for example, a transfer to hospital for prisoners facing acute crises within 28 days is widely viewed by criminal justice stakeholders as unlikely to happen. We need to review if such cynicism is merited, because the prison reform aspects of this bill are not minor. They shouldn't be treated as Cinderella clauses. They are, to my mind, crucial. We can't pass this Act and leave prisoners who ought to be in hospital beds abandoned in squalid conditions in jails. And additionally, it's not fair to prison staff, because, to quote Andrew Nielsen from the Howards League, our overcrowded prison system that has been asked to do so much with too little for too long is ill-equipped to help people who require intensive support for their mental health. I recently visited Five Wells Prison in Wellingborough with my Academy of Ideas hat on. The new leadership team at Five Wells are doing some fantastic work on purposeful rehabilitation activities, and we hope to do a joint project of our Debating Matters Beyond Bars with them there. But I chatted to the team more generally, who've worked in a variety of prisons over the years, and they all noted that the time and emotional strain on staff when dealing with psychotic, very poorly prisoners, and the gory examples of inmates, from examples such as awful things like eating their own faeces, very bloody attempts at self-harm, etc., have been totally demoralising on officers, and has one of the reasons why I think we've seen people using those segregation units I talked about earlier, but also have had a destabilising and frightening impact on other prisoners. Sharing space with those with paranoid delusions who present a violent threat to themselves and others is no joke, is making prison difficult for everyone. So it's crucial we get this right in the context of an overstretched prison crisis, and a specific view, in my mind, would focus minds. But I also think we can't let this bill pass into law without acknowledging that there is considerable public disquiet about the relationship between criminal justice and mental health care. What do we do about the detention of those convicted of serious crimes due to diminished responsibility, where professionals see secure hospitals as more appropriate than prison? I'm sure we can all recognise that for many victims and their families, this hospital option can feel like an injustice. I am, of course, thinking of the high-profile and controversial case of Valdo Calocane. According to the recently published independent investigation, it was repeated failures to treat Calocane's paranoid schizophrenia and violent outbursts that left him free to kill Barnaby Webber, Grace O'Malley Kumar and Ian Coates in June 2023. More personally, in relation to the bill, the families of these tragic victims fear that Calocane may have been spared prison due to incomplete evidence presented in court, especially about his mental capacity. This is now exposed in the 302-page investigative report, and the families have concluded, quote, "This was a man who actively avoided his medication and treatment, knowing when he didn't take his medication that he would become paranoid and violent." This is, of course, interesting for our deliberations, because we now know that doctors responsible for Calocane's case reportedly ignored nurses treating him in the community who begged for him to be put on a CTO to ensure he took long-acting antipsychotic drugs. And why were they ignored? It seems that the clinical team at Nottinghamshire Health Foundation Trust made decisions, and I quote, influenced by the draft Mental Health Bill of 2022. Those medics were very conscious of legislation down the line that seeks to raise the threshold of detention, reduce the use of CTOs, and the call for a reduction of compulsion of medicating patients in the community. Then there's patient rights in Calacone's reluctance to take medication because he didn't like needles. And staff were, we're told, acutely aware of the bill highlighting the disproportionate use of restricted practices on Black African or Black Caribbean patients, and so on and so forth. So surely, and the reason I raise this, we need to ensure that this bill doesn't lead to such misinterpretations with tragic unintended consequences. When I asked the Minister how the findings of the Calacone investigation would impact on this law, her answer, I think, seemed unclear to me in terms of timings. But if lessons will be learned is to be more than a placating evasion, perhaps this amendment, or something more precisely worded, would give the government a chance to review the impact of the Act on criminal justice and mental health in general, and the whole dispute about prison versus hospital for the most serious cases could in fact then be being dealt with. What we will also need to review is exactly how the Act will interact with the actual prison estate and not an imaginary one. Regardless of the 28-day rule, there will still be seriously mentally ill people incarcerated in prison. And one complication is that some prisoners are likely to deteriorate in jail, so much so that they arrive at an acute crisis phase. And this is because, in some instances, of the inadequacy of mental health service provision in prison. One evidential marker of this relates to recent revelations that 4 out of 10 prisoners who have taken their own lives in custody in recent years did so because they were denied adequate healthcare before their death. I want here to give huge credit to the journalism of Amy Claire Martin of The Independent. Amy has recently exposed the scale of neglect, showing that 104 out of 233 self-inflicted deaths investigated by the prison's watchdog between 2020 and 2023 show failings in mental health care in jails. I'll just focus on a couple of cases to illustrate the point. The coroner's court heard of one prisoner who took his own life at HMP Risley, 37-year-old Jason McCade, who did not eat or sleep for 3 days and begged for help after being put in one of those infamous segregation units that we discussed earlier. Jason's family repeatedly warned he was going to take his own life, but he still wasn't seen by any mental health clinician in the 72 hours before his death. No wonder they described his treatment as medieval. Similarly, at another inquest in December, the prisoner Hader Jeffries, it was found that it was neglect and a failure to procure basic medical attention that actually contributed to his death. Hader took his own life in HMP Coldingley in February 2023. Shortly before his death, he was observed naked on all fours in his cell, barking like a dog, in the throes of severe depression and suffering acute psychosis. Yet staff did not provide him with any medical attention. That is, of course, shocking, but perhaps more shocking is that Mr. Jeffries' mental health rapidly deteriorated after he was recalled to prison, having successfully rebuilt his life on the outside. The recall, based on the unproven and later withdrawn allegation, was under the terms of that discredited and abolished sentencing regime, IPP. What's more, the coroner noted that the postponed parole hearings, plural, and she said, quote, more than minimally contributed to the development of psychosis due to psychological stress. Now, complaints about the inequities of IPP sentences are familiar in this House and to the Minister, and yet the state still incarcerates 2,600 people indefinitely. And although there's now brilliantly been reform of, for example, the draconian IPP recall regime, still there's a whole body of evidence to suggest that mental distress is one of the most pervasive and intrinsic factors associated with IPP sentences, and not because of pre-existing mental health issues, but a distinctive characteristic of the specific sentence itself over and above the general experience of imprisonment. The way the sentence is psychologically toxic is well documented in the literature, assessed invaluably in UNGRIP's report titled The Mental Health of People Serving Indefinite Sentences for Public Protection, by Donna Mooney and Sophie Ellis. Pertinent to our discussions of this bill, IPP prisoners are often very frightened to disclose their mental health problems or ask for help from prison staff because poor mental health is regularly cited as a reason to knock back their parole. So this can lead to untreated illnesses becoming more acute and in need of the provisions of this legislation. It also suggests that some of these IPP prisoners are effectively being detained by the state because of their mental health challenges, without that being acknowledged, and this could be seen as a sort of section by the back door. These sort of catch-22 situations for IPP prisoners are illustrated by the harrowing plight of Thomas White, the father who spent 13 years in prison for the street robbery of a phone, which I raised at second reading. 2 medical reports last year laid bare the toll of his IPP jail term on the 42-year-old Mr. White, warning that his lengthy incarceration had created impermeable barriers to his recovery. Recently, Thomas set himself alight in his cell in desperation, and since then the latest news from his family and his Member of Parliament is just awful. He's now totally disengaged and has lost hope. And the cause is the denial of a hospital transfer, the very key part of this bill. Thomas's sister, Clara White, explains the dilemma. She says, if I took him to A&E and sat there for 3 hours, he would be admitted to hospital. I thought the 3 hours bit was optimistic myself, but anyway. He would be admitted to hospital. But prison staff have said he'd have to display 3 months of stability in prison to be reassessed for a hospital transfer. So a man with paranoid schizophrenia has to pretend he hasn't got it in order to get hospital care. That is ludicrous. And it does seem to me that that's a kind of problem that this review and a special audit that I'm suggesting in my amendment would allow us to look at, and look at the particular impact on IPP prisoners as a specific group. And finally, I wanted to raise an issue that threatens to confuse our aim of reducing the use of prison as a place of safety, and that is the contested diagnosis of personality disorder, often used in fact to define and label people as dangerous or risky, and potentially masking mental health problems. It has been used in relation to IPP prisoners whose failure to accept inequities of their sentence can be pathologised as antisociability and disordered personality, but it's also a syndrome that's prevalent in the Women's Estate and Young Offenders Institution. And my main query is whether those put on the offending personality disorder pathway, which by the way does not require a formal diagnosis by medical staff, doesn't muddle up those prisoners who might need more direct mental health treatment and instead just get the label of behaviour disorder. I hope at least that the level of probing that the government can explain how we can ensure that the parts of this legislation relating to prisons are not provisions that might tick a box but actually get neglected, and that they will have a real impact. At least a review would help ensure that we keep our eye on prisons, and I beg to move.
Proposed.